All right, good afternoon, everyone, and thank you for joining us today for today's webinar, First Amendment Update for Campus Professionals. My name is Lori Sabata, and I'll be serving as your technical producer for the broadcast today. And first, before I get started and get too far down the road, I wanted to do a quick tech check just to make sure that you can see the screen. You should be seeing the title slide that has the webinar title on it, First Amendment Update for Campus Professionals. You should be hearing me talking. If you can say yes to both of those things, if you wouldn't mind just taking a look real quick at there should be a control panel, or it's like a strip or a ribbon at the bottom. You'll see a little hand there. If you could click on that, that lets me know that everything is A-OK on your end, and I'm seeing nothing but raised hands. So that is good news. Thank you so much for doing that. I want to go through a few housekeeping items for our presentation today before I go ahead and introduce our speaker for today and get started. I wanted to talk a little bit since I was just bringing your attention to the control panel at the bottom. You should see something there that says Q&A. That is something that you will use for, at the end of the presentation, we're going to take time to answer your questions and have some discussion. So at any time when you think of a question, just please feel free to go ahead and type it in that Q&A box. And I'll be monitoring that throughout the presentation, and then we'll take care of getting those questions answered towards the end. And you don't have to wait until the end. If you think of a question, just go ahead and type it right in at any time. We'll be keeping an eye on those. And also, if you should at any time have any technical difficulties, like you all of a sudden can't hear or the slides don't seem to be advancing, please just go ahead and you can put it in the question box and I'll see it, or you can also use the chat feature as well to reach me, and I'll attempt to assist you with any issues you may be having. I also wanted to mention that we'll be recording the webinar today, so that we'll be able to send that link out a little bit later for any of your colleagues who may have missed it today. So I did want to go ahead and introduce the webinar and the speaker. This webinar today is brought to you by the Hawaii Public Policy Advisory Committee, which works to help the association better understand legislative and policy issues facing the profession. First Amendment issues represent one of those topics that consistently rises to the top for housing administrators, and the committee sought out some additional programming for our members. We are pleased to have so many of you with us today. With that said, I'd like to introduce today's presenter, Scott Schneider. Scott is a partner at Husch Blackwell. His practice focuses on complex issues in higher education, K-12 education, labor and employment, and traditional labor relations. Schneider is also an award-winning professor at Tulane University, where he teaches higher education and labor and employment law. And he has been a contributor to media outlets such as NPR, the Chronicle of Higher Education, Inside Higher Ed, CBS News, and the Wall Street Journal. Last but not least, over the years, he has become a friend to Hawaii. So welcome, Scott.
Thank you so much. I'm hoping that everybody can hear me, and I'm looking forward to being with you, I guess, this morning, depending on where you are, this afternoon, to talk about this topic, First Amendment. And it's a tough one to do, a lot of territory to cover in an hour, and I'm going to do my best to provide you with an overview of the state of First Amendment law in a variety of different contexts. And I also want to spend a little bit of time towards the end of the webinar talking about the Oberlin case, which has received a lot of attention. So I'll jump right into it. Hopefully I can advance the slides. There you go. So I'm going to start with a story. And so the picture here is of a professor, or formerly a professor, at the #1 university in all of America, and at least from a football perspective, and that is the LSU Fighting Tigers, Go Tigers, #1 team in the country. And sorry, I had to get that in there. And this is Teresa Buchanan, and Teresa Buchanan worked, as I alluded to a second ago, as a professor, a tenured professor at LSU. And she taught a course for students who wanted to become, at some point, PK through 4th grade teachers. All right, so that's the setup. This is Teresa Buchanan, tenured professor at LSU. What she teaches is a course on education issues, especially geared to pre-kindergarten and 3rd grade future teachers. And so what I'm going to do for a second is we'll do a fun role-playing exercise. Instead of playing doctor or lawyer, you will play, I guess, the Title IX coordinator at your institution, which is a terribly exciting position. Everybody that does Title IX work is rich, and so this will be a very fun role-playing exercise. And so you come into the work week on Monday, and in comes student one. And student one, before you've had your first cup of coffee, comes to you and complains about Dr. Buchanan's comments regarding her sexual relationship with her fiance, the student's sexual relationship with her fiance. Apparently, Dr. Buchanan in her teaching is talking about that. And here you see a quote. Dr. Buchanan has offered us condoms and told us it was unacceptable to become pregnant, and that if you chose to become a mother, that your grades would suffer for that. She told us, she also said to all the students, enjoy the sex while the sex is good. If you're dating, make sure the sex is good, something along those lines. She told me that my fiance was supportive now while the sex is good, but just wait until you're married for 5 years. And so student one obviously doesn't appreciate these sort of comments, doesn't think they have any place in the course that Dr. Buchanan is teaching her, and is now going to the university to complain to the Title IX coordinator. Along the same lines, this is, I love this image here. This is, I think, me at the end of virtually every Monday and Tuesday of the last 3 months. So that's why I picked this one. Then student two decides to walk in to the Title IX coordinator's office and also files another complaint regarding the way in which student two is being treated by Dr. Buchanan. You see here, Dr. Buchanan recorded me crying during an assessment team meeting. She was aggressive and yelled at me. I felt attacked. And if that were not enough, we go to the next day, and we're back at work. We haven't retired from our position as Title IX coordinator at the university, and we open up the mail, and nobody sent us an email. It's an actual letter, and we receive a letter from a variety of students in Dr. Buchanan's class who alleged that she made a host of offensive classroom comments, such as, and you see these in quotes here, a woman is thought to be the D word, lesbian if she wears brown pants. It was a choice to be in the program, and it was not the fault or problem of the professors if any of us chose to be mommies or wives, and not to expect to get an A in the class if you were a mommy or wife. And then she'd also use extreme profanity on a regular basis, including the P word. All right, so these are the facts that have presented themselves to you as the Title IX coordinator at your institution. All right, so what do we do with this? And I think at most institutions, I haven't looked at your anti-harassment or anti-discrimination policies, perhaps all of them, but I have a sense from the many I have looked at that these sort of comments would probably run afoul of institutional non-discrimination provisions and policies. We have a lot of gender-based comments. We have a lot of anti-pregnancy comments as well. So we have potentially the sort of comments that would implicate a whole host of issues pursuant to our non-discrimination and Title IX policies. So you go, you do your small I investigation, and you decide, hey, this is a potential violation of the policy that we have. I need to now bring Dr. Buchanan in and get her side of the story, which is what you do. And I don't have you in front of me. If I did, I would expect you to be shouting out from the rooftops the answer to this question. When you talk to Dr. Buchanan about these inappropriate comments, and you note that they are potential violations of our policies, what two words does Professor Buchanan use to defend herself? This would be the point where you'd be screaming out with vigor and excitement the phrase academic freedom. All right, so those are the two words I was looking for. If you got that right at your home institution, give yourself 25 points. Congratulations. That is well done. You're well on your way to a good grade in this webinar. And so that's what she does. She defends her speech on the basis of academic freedom, which at some level, as we'll talk about now, is grounded in the First Amendment of the Constitution. And so let's talk with that as backdrop. I'll introduce you to some general rules with respect to the First Amendment that we can then hopefully take and apply in a variety of different contexts. The first rule with respect to the First Amendment is that speech at public institutions is generally going to be protected by the First Amendment. As a public school, as a public university, a public college, we are in essence state actors pursuant to the First Amendment. And because of that, speech in a variety of contexts is protected on our campuses and vis-a-vis interactions with our institutions. I'll talk a little later about, well, just because you're a private institution doesn't necessarily mean that you are immune from these protections. We'll talk about that in a second, but first I want to lay the foundation for the First Amendment. Second, public employees, staff employees, professors, and students at public institutions are all protected by the First Amendment. We'll talk about what do those rights look like for public employees and professors and students in a moment. Number three, the standard for a certain kind of speech to not be protected by the First Amendment is high. Another way of thinking about that is almost all speech is going to be or give rise to concerns regarding the First Amendment. And we'll talk in a second about some of the common exceptions to that. And finally, I just want to be clear because there's a lot of sloppy rhetoric about this issue. There is no, quote, hate speech exception to the First Amendment. You will see Twitter lawyers, people on the Twitter talking about that's not free speech, that's hate speech. That is empty rhetoric from a legal standpoint. There is no, quote, hate speech exception to the First Amendment. We can't, somebody is espousing a political view. We don't get around the First Amendment implications of that by simply labeling it as hate speech, all right? So those are the four big First Amendment rules. And now what I'd like to do is do a little bit of a deep dive into point three. And what I will say is this, and I feel comfortable saying that in terms of history, there was a real evolution in the way in which courts interpreted the First Amendment vis-a-vis public institutions, which started 1960s, 1970s. So it started in that period of time. And obviously, I think we don't have to be history majors to understand what was going on at that time and why we were perhaps reconsidering the ways in which we traditionally handled First Amendment issues. We had the civil rights movement. We had war protests. All of these things, by the way, bubbled onto and impacted college campuses around the country. And so in that time period, as we started to rethink the First Amendment and its application to public institutions, one of the things we started developing were categories of speech that were unprotected by the First Amendment. So I'll talk just briefly about three of those, the three most significant of those unprotected categories of unprotected speech. The first one is what is called a true threat. And I like this iteration from the Ninth Circuit in 2001. What you're looking for in a true threat case is that someone is directing another or a group of people to produce or incite imminent lawless action. That's number one. Imminent is very important. It needs to be, I want you to do this now, all right? It can't be, there's a case, a Vietnam War case, where someone said, hey, if I'm drafted and have to go to Vietnam, the first person I will point my rifle at or put in my crosshairs is LBJ, Lyndon Baines Johnson. And the question was that a true threat? And part of the Supreme Court's analysis of that case was to say there was no imminent lawless action that was being incited. This was conditioned on a variety of things happening. So it has to be imminent. And number two, the statement, the true threat has to be likely to incite or produce such imminent lawless action. So in that same case, one of the things the court relied on was how did the audience react to this threat? And the court noted that everybody laughed and guffawed. And so therefore, not only was there no request for imminent lawless action, that threat, as stated, wasn't likely to incite or produce such action. So that's true threats. And I want to be very clear that this is a very, very narrowly interpreted category of unprotected speech. All right. If we're going to say something is not protected because it is a true threat, we face a fairly substantial burden to prove these two elements. All right. So that's number one. Number two is what we've called fighting words. And I'll talk just briefly about the case, and this is from the 1940s, where the fighting words doctrine originated. And this is a case called Czaplinski versus New Hampshire. Long story short, we had Walter Czaplinski, who's a Jehovah's Witness. He's standing on a street corner. He's distributing materials where he's denouncing other religions as a racket. Anything other than Jehovah's Witness is a racket. Catholicism, fill in all the blanks. Long story short, a crowd starts getting around Walter, gathering, and they're upset. This is 1942, a very conservative era. Long story short, a police officer looks at Czaplinski and says, you need to cut this out, because if you don't stop saying these sorts of things, there's going to be a riot on our hands. And long story short, Czaplinski responded to the police officer by saying, you're a damned racketeer, which I guess was a really big insult in the 1940s. I'm going to go around calling people racketeers today. And you're also a damned fascist, and the whole government of Rochester, which is where this was taking place, are fascists and agents of fascists. And so what does the police officer in that case do? Long story short, he arrests Czaplinski, who then challenges his arrest by claiming that the arrest was for his speech, which violated his First Amendment rights. And long story short, the Supreme Court ultimately decided he was wrong, that what he had uttered were fighting words, which this is a good definition in number 2, words by which their very utterance can lead to injury or tend to incite an immediate breach of peace. All right, so that's what the court said that Czaplinski had engaged in, and therefore his speech was unprotected. Now, I alluded to this. This is a case from 1942. What I am comfortable saying is it is hard to find a case in the last 30 years where a court looked at an allegation of this is a fighting word exception to the First Amendment and said, we agree with you. This exception has been significantly, as a practical matter, narrowed down. In fact, if you were to ask me to predict if the Supreme Court were to hear the Czaplinski case today, my guess is they may have come to a very, very different conclusion. So I put fighting words in there. It's recognized as a category of unprotected speech, but as a practical matter, for all intents and purposes, it's really hard to find a case that qualifies for this fighting words exception. The last one, the last category of unprotected speech is what we call obscenity. There was a test articulated in the Miller versus California case from 1973. It's a 3-prong test. I decided only to include 2 prongs because this slide looked very wordy with 3 prongs, and I didn't think it was necessary, so it was an aesthetic decision. But long story short, the iteration you can think of is the Potter-Stewart iteration, which, what is obscene? I don't know, but when I see it, I'll let you know. It's basically, and I've misquoted Potter Stewart, and of course cannot remember the exact quote, but generally speaking, it is a very subjective determination. I don't know what's obscene, but I'll tell you when I see it. You see this as well in the first 2 prongs of the Miller versus California test. Does the average person applying contemporary community standards, would they find the work taken as a whole that it appeals to prurient interest? Whether the work taken as a whole lacks serious literary, artistic, political, or scientific value. And so let me back up here. Again, very hard to find contemporary cases where a court has said, what you said, what you uttered, what art you put out into the universe is obscene and therefore not entitled to First Amendment protections. One obvious example would be something along the lines of child pornography, all right? Another exception that some friends of mine who are criminal defense attorneys tell me happens with some frequency is obscenity prosecutions over you've exposed yourself in public. But generally speaking, obscenity is a very, very narrow exception to the First Amendment, all right? So back to what I was saying at the very beginning before I went into these exceptions, I just want to make clear the standard for speech not to be protected by the First Amendment is high. And these are all very, very narrow exceptions to the First Amendment. Now, I want to try to introduce one more concept here, and I'll put, I'm trying my best to be my best law professor self, but long story short, we have the state as an actor, right? We have a public institution as an actor, and think of the police department who arrests Czaplinski, for instance, for his speech in that case. And then we also have the state as an employer, okay? We have the public, the governmental entity as the employer. And while as an actor, I might be circumscribed from punishing someone for the exercise of their speech rights, as employer, I am circumscribed, but not as much as if I was just dealing with you not as an employee, but as an everyday citizen. So I want to talk about the First Amendment in the employment context and how we've basically balanced the rights of the state as an employer with the free speech rights of the public employees, all right, of its public employees. So long story short, there is something, and I can do this, I don't have a ton of time, so I won't get into an enormous amount of detail, but there is something that has been established which is called the Pickering-Connick test. And again, the idea here is to balance my rights as an employee to speak with the employer's, the public employer's right to have an efficient, orderly workplace. And so the first thing I'm looking at is if someone comes to me and says, let's say I become a plaintiff's attorney, and someone comes to me and says, I was fired by my public institution for exercising my First Amendment rights. This is the drill I would go through, established by the Pickering and Connick decisions by the Supreme Court, a couple of decisions that go back, I think, 20, 30 years. These are the two questions I would be asking. First, did you speak about a matter of public concern or public interest? If the answer to that is, I was just griping about my own personal and private life, then you're probably not going to have a First Amendment related claim if you were fired by the employer for your speech. Because the way we, again, have balanced rights is to say you're only entitled to protections here as an employee to the extent you are speaking about a matter of public interest. If it's speech about a purely private matter, not protected. All right, so that's number one. And we'll talk in a second about, well, how do we assess whether or not something is a matter of public interest? Number two, assuming that the speech is a matter of public interest or public concern, it doesn't mean you get carte blanche to say whatever you want without repercussions, because then what we need to do is go to number two, which is we need to balance the employer's interest in an orderly and efficient workplace against the speech rights of the employee, all right? Taking into account, I'm going to read this, I don't do this a lot, but I will read this. Taking into account things like whether the speech restriction is content-based. And what do I mean by that? That you have a particular thing that you are saying, that you are espousing a fairly specific ideological position, and it's because of that you're a conservative or you're liberal that I'm disciplining you for, as opposed to you're talking about a topic that we don't want to talk about regardless of the content or your viewpoint, all right? So to the extent we have viewpoint or content-based restrictions on speech, those are viewed with a high degree of skepticism by courts. We also look at the circumstances of the speech, the strength of the employee's interest in speech, and whether the speech genuinely disrupts discipline and order and interferes with relationships. This is a balancing test. There's no mathematical formula to say whether or not the employer's interest in order trumps the First Amendment rights of the employees. But you can see the sort of arguments that attorneys who litigate these sorts of cases would be making to, and this is, again, this is a hot area in First Amendment law where lawyers, when they're litigating, are arguing with different facts about whether whose rights trump who. So it's a balancing test. And only when, going back to my hypothetical, the employee's interest in his or her free speech trumps the employer's interest, would I have a viable claim? So again, backing up, two things. I need to say, is this speech a matter of public concern, number one? And number two, given the full panoply of facts here, do your speech rights, in essence, outweigh the employer's interest in an orderly and efficient workplace? All right, and that's going to be very, very fact-intensive inquiry. One more caveat I'll throw out there, and I don't want to overcomplicate this, but I'm giving you the basic framework. There's a case, it's called Garcetti versus Ceballos. Short version of this is we have a district attorney who is in Los Angeles, and he objects to the way in which other district attorneys are handling things that he thinks are frankly unethical. And he is disciplined for that. And the question that he raises, challenging the discipline, is whether or not this violated his First Amendment rights to speech. He argues this is a matter of public interest. This didn't impact the orderly and efficient workplace, et cetera, et cetera. And what Justice Kennedy, who wrote the decision in Garcetti versus Ceballos, said, and it's interesting and it's potentially problematic, and we can almost see, since this case, courts trying to walk this back a little bit. But what the Garcetti court held is that when public employees make statements pursuant to their official duties, the employees are not speaking as citizens for First Amendment purposes, and the Constitution does not insulate their communications from employer discipline, all right? So in Garcetti, when we're making a statement pursuant to our official duties, even if it's a matter of public concern, the Garcetti case holds, I was about to say indicates, but holds, I think is the fair reading there, that the employee is not entitled to First Amendment protection in that setting and can be disciplined, all right? Now, let me back up for a second. Garcetti, the opinion is written by Justice Kennedy, or former, I don't know, he's retired, so former Justice Kennedy, who was for a long time very, very sensitive to the unique role of higher education institutions and was very big on what has been called academic deference. All right, we see that, by the way, in affirmative action jurisprudence. We see it in a variety of contexts. And so throughout the Garcetti opinion, or at least in various places in the Garcetti opinion, Kennedy seems to allude to the fact that I don't know that this ruling applies to colleges and universities, or at the very least, we should exercise some care here. And why is that? And that's not Justice Kennedy, and I'm going to forget the first name, but this goes back to, this is Sweezy, and I can't remember his first name, and it's literally going to make me mental at this point. But Sweezy was the plaintiff in Sweezy versus New Hampshire, which is the case which recognized, I think it's fair to say for the first time, the idea of academic freedom, in that it is moored in the First Amendment, in that there are heightened First Amendment concerns which take place within the academy, all right? And so if we were to apply Garcetti versus Ceballos, for instance, to the case we were, let me see if I can pull it up, just talking about, the Buchanan case, the argument would be, if Garcetti applies in this setting, the argument from the university would be she was speaking pursuant to her official duties as a professor, and therefore, under Garcetti, her speech is not protected, all right? Now, as I've alluded to, Kennedy in Garcetti says, I'm concerned about this in higher education. And what I can say, and this is via very simplifying things, is there is an open question about the extent to which Garcetti applies in the education setting, specifically higher education, and most notably when it comes to professors in their classwork or in their research. There are a number of cases saying Garcetti doesn't apply, including this one. And so let's fast forward back to this one. This is a case that FIRE decided, so let me fill you in on some facts. The students walk in, go to the Title IX coordinator, say all of these things, and the university, after going through their process, decide to revoke the tenure of Professor Buchanan. Okay? They revoke the tenure of Professor Buchanan. She alleges that this was a violation of her First Amendment rights. All right? And ultimately, FIRE decided to take up this lawsuit and sued LSU for violating Dr. Buchanan's First Amendment rights. And I'm just going to say this, the people at FIRE are fantastic. We have differences of opinion on certainly due process things around the margins and some First Amendment issues. They have wonderful resources, though, legal resources online that flesh a lot of this out. So if you're looking for something interesting, more reading material to look at, this FIRE website has some interesting stuff. All right, so she decides to sue LSU for her termination. The case goes to a district court judge who says, no, you lose. And the reason you lose is that we don't think what you were speaking about is a matter of public concern. All right, so that's number one. Number two, even if we thought that what you were speaking about is a matter of public concern, and we don't, by the way, long story short, this balancing test that I talked about before ends up siding with the university because this was a very disruptive way for you to handle your class. Case then goes up to the Fifth Circuit Court of Appeals, which is in the great city of New Orleans, Louisiana. I'm in Austin now, but I'm originally from New Orleans. If you're in New Orleans and you want to do a nerdy tourist thing, go check out the Fifth Circuit Court of Appeals. It is gorgeous, and they have the coolest library with the coolest leather chairs humanly imaginable. With that said, this case goes to the Fifth Circuit Court of Appeals, and the Fifth Circuit ultimately agrees with the district court and says, Teresa Buchanan, you're out of luck. First, I want to be clear, the Fifth Circuit comes back and says that thing I was talking about with Garcetti doesn't apply when it comes to university professors. So that's number one, and that's significant. Number two, the court says, was Buchanan speaking about a matter of public concern? And again, if the answer to that question is no, she doesn't have a First Amendment claim. And the court came back and said, no, this was a conversation about your private sex life and the private sex lives of your students, not a matter of public concern. Buchanan comes back and argues this is part of pedagogy, depending on how you say it. What I was trying to do, and I am giving this short shrift, what I'm trying to do is toughen up these teachers for the sort of language they're going to hear in their elementary school education environment. So what I'm saying is all part of my pedagogical approach. Let me spend a couple of minutes just talking about those two bottom issues, all right? First, when it comes to assessing whether or not an employee is speaking about a matter of public concern, again, not hard and fast rules here. These are the sorts of things that lawyers argue about all the time. What I look to is the content, the form, and the context of a given statement. Is it discussing a matter of political, social, or other concern to the community? If so, then it's a matter of public concern. If I am complaining, for instance, in a classroom setting, or let's make it even cleaner. If I'm on Twitter and I'm saying, oh my goodness, the people in the university are misappropriating funds, all right, that's a matter of public concern. Why? Because the public has an interest in how its public institutions spend its funds, all right? So that might be a matter of public concern. If it's a mixed matter of public concern and private, courts say it's a matter of public concern then. Here, again, in Buchanan's case, the court said, no, this is purely private. No public concern issue here, doesn't rise to a First Amendment issue. I just want to briefly talk about the pedagogy argument that she makes. And I'm going to quote here from the Fifth Circuit opinion, and I apologize for how wordy this slide is. It offends my aesthetic sensibilities, but I thought it was important. So plaintiff likens her case to Hardy versus Jefferson Community College. In Hardy, the Sixth Circuit held that a professor's right to use the words the N word and the B word during a classroom discussion on the power of words to marginalize and oppress outweighed the college's interest in regulating offensive speech. So I want to stop there just for a second. In the Hardy case, the professor taught a class on introduction to interpersonal communications, all right? And specifically, there were lectures that he was delivering which examined how language was used to marginalize minorities and other oppressed groups in society. And in teaching those classes, he used the N word, he used the B word, and students went forward and complained about that. And ultimately, he was disciplined. I think he was terminated. And the question was, is this protected speech? Did the school violate his First Amendment rights? And long story short, what the court came back and said is, number one, we think this topic is a matter of public concern. And more importantly, from an academic freedom standpoint, this was a necessary part of the lecture. It was consistent with the professor's pedagogical choices, and we are going to be very hands-off when it comes to that. To the extent you are using language that is necessary to communicate ideas in a classroom, that's going to be entitled to a high degree of protection. Right? And in this case, his use of those words were connected to pedagogy on very specific factual allegations. Context is super, super important. Now, the Fifth Circuit in the Buchanan case says, no, this is totally different from Hardy. There's no pedagogical connection between what she is saying and the classes that she teaches, and therefore her termination does not violate the First Amendment. All right. Boy, that's a lot of material in 41 minutes. I'll apply it one more time just to make sure you get it. So this is a picture of Louis Wozniak. He was a professor at the University of Illinois at Champaign-Urbana. And long story short, and which I think I've said now 5 times, and I apologize, Louis Wozniak was a really good teacher. He also had a sense that he perhaps was a better teacher than what other people thought he was. And he was upset when a student organization decided to award a teaching award to one of his colleagues and not to him. What did he decide to do? According, at least to the case, he decided to engage in a harassment campaign against the students who had given the award to the other professor. The university gets involved in this and decides this is inappropriate, and they separate him from the institution. He comes back. What does he argue? That my challenging this award and going to these students was an act of speech protected by the First Amendment. How do we analyze that claim? The same way we just talked about. First off, is this a matter of public concern or public interest? And what the Seventh Circuit Court of Appeals said was no. This was a professor griping about something personal to him not getting a teaching award, and therefore is not a matter of public concern, and therefore he didn't engage in speech protected by the First Amendment. But even if he did, the court comes back and says, the way in which he went about this was way too disruptive for the university community, so that balancing test that we talked about before weighed in favor of the university as well. Now, a creative lawyer for the professor may have come up with a way to cobble together an argument that what he was doing was speaking on a matter of public concern. And had that lawyer been able to do that, he would have, or she would have, been able to surmount that first burden. But that's the way we analyze these sorts of cases, all right? Employee speech cases. I previewed this for a second. I will spend a hot minute talking about this case, and then we'll transition to Oberlin. I showed this slide to my 13-year-old, and he asked me why I had George Washington in a slide. The kid is brilliant, but that's not who this is. George Washington would never wear those khaki pants. This is George McAdams, and George McAdams worked at Marquette. Marquette is a private university. George Adams was interimly disciplined, depending on how you phrase it, for things he said on a blog and ways in which he talked to students. George Adams says, "This violates my right to academic freedom." Marquette's argument to that is, well, academic freedom is a constitutional idea grounded in the First Amendment. We're not the government. We're a private university. This doesn't apply to us. And George McAdams' attorneys made a very creative argument, which is, yes, the Constitution does not apply to private entities, but you've agreed via contract to honor academic freedom principles. It's in my engagement letter, it's in the faculty handbook. Oh, by the way, it's in your student code of conduct as well. And therefore, you have committed yourself as a private institution to follow First Amendment provisions, but you've done that via contract. And ultimately, it's a case that went all the way up to the Wisconsin Supreme Court, and they sided with McAdams on that theory. So just because you're a private institution doesn't mean you're totally immune from this conversation, because you may have, via contract, either with your employees or your students, agreed to recognize these principles. All right, I'm going to do a quick gear shift, and we're going to talk, it's a lot of material to cover, but I want to spend a little bit of time on the Oberlin case, and then also look at your questions. So there has been a lot said about this case that I think is wrong, and that at some level I think may be unreasonably and needlessly alarmist. And so with that as backdrop, and I've had conversations about this case for a while, let me just talk about it briefly. And for those of you all who don't know, this is a case where a jury in Ohio issued a $44 million jury verdict against Oberlin College. And that verdict, and there's a great article that just came out in the Chronicle of Higher Education about this case that gives you sort of the rundown. I cannot remember the name of it to save my life. But what happened here was we have a bakery, Gibson's Bakery. You see the picture in the top corner here. And there were two African-American Oberlin students who were in the bakery. The owners, who are white, suspected, and it turned out they were right, that one of the African-American students was shoplifting a bottle of wine. As the African-American student left, the Gibson's employee decided to chase that student and detain him. There's different accounts about whether he was put in a chokehold, all that sort of stuff. And students saw this, Oberlin students saw this, and thought what? That the Gibson's Bakery people were racially profiling an African-American student. And what they started to do was organize protests outside of Gibson's. And you see some of the pictures here. This right picture, you see there's a town and gown thing, because Oberlin itself, very conservative. The community around Oberlin, much more conservative. And administrators, when this protesting started, were concerned about the potential for violence associated with the protests, et cetera. All right, so that's sort of the setup. I'll get into the weeds in a second. Let me give you a few principles, though, right up front when it comes to student free speech rights. First off, Oberlin students, at least vis-a-vis Oberlin, don't have free speech rights unless Oberlin has agreed to that via contract, because Oberlin is not a state actor. It's a private institution. For constitutional free speech rights for students, the case that we go back to, and again, 1970s case, is Tinker, the Tinker case, where the court came and with eloquent language said, students don't shed their constitutional rights to freedom of speech or expression at the schoolhouse gate, which is a neat quote. You've probably heard it 500,000 times, and it would be left to other schools, other courts to basically assess, well, what does this mean? All right. So the primary source of student free speech rights starts with the Tinker case and then flows from a variety of cases that have come out since then over the last 4 decades. There are also, I was just in the great state of California, in Los Angeles, there are state constitutional provisions and state free speech statutes which extend these sorts of constitutional protections to private school students. In California, it's called the Leonard Law. In other states, I don't know, it may be called other things. And then the last source of student free speech rights is what we talked about already with the McAdams case. It is, what have we agreed to via contract with our students in our codes of student conduct, et cetera. So those are the sources of student free speech rights. A couple of just quick principles when it comes to student free speech principles. And by the way, the case law on this topic is so all over the place. I've tried my best to synthesize the case law here, but it's all over the place and it's very, very difficult to synthesize. But big picture, public school students have protected speech rights within institutions of higher education. Again, those can be extended to private school students depending on state law and contract. When it's students engaging in core political speech, the Tinker case is a great example. The students wanted to wear an armband protesting the Vietnam War. Those students are entitled to what are called heightened speech protections. So when you're speaking about core political things, that's when the antenna, that's when the court's attention is going to be its most heightened, and where courts are going to be very sensitive to the free speech rights of students. Viewpoint-based restrictions on student speech is likely not going to survive judicial scrutiny, all right? So if we say, you can talk about all sorts of wild things, but Richard Spencer, when you come to campus, we don't want you on campus because you espouse a fascist right-wing ideology. That's going to be problematic according to courts, because that's going to be the sort of viewpoint-based restriction that typically creates problems for schools. When there are conflicts between student speech rights in a classroom and legitimate pedagogical concerns of the professor, all right, in the classroom, we have a professor arguing with a student about a subject. Generally speaking, courts tend to side with the institution or the professor in those sorts of cases. And then the form of the speech, where is this speech occurring? Form analysis also plays a role in assessing speech. All right, so those are some general student free speech principles. Let's now fast forward back to, or rewind back to the Oberlin case. So at Oberlin, when the students are doing their protests, one of the things that they are doing is handing out this flyer, the one I have on your screen right now. Don't buy from Gibson's. This is a racist establishment with a long account of racial profiling and discrimination. Today, we urge you to shop elsewhere, blah, 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 blah. And you can see some other facts that are alleged in the second part of the flyer here that outline what supposedly happened, all right? Now, if it was only the students handing out this flyer, all right, from Oberlin's perspective, I think they would have been fine. There would not have been liability attributed to them. We cannot be liable for, generally speaking, the acts of speech or protest that our students engage in. What the attorneys in this case, the plaintiff's attorneys, focused on, though, was the allegation that the dean of students and other members of the Oberlin Student Affairs team, that they were actively participating in the protest and handing out those flyers. Now, I want to be clear. This was a contested fact. The university, in this case, is subject to appeal, which is another cautionary note here. The university said, we did not hand out flyers. All we were there was to provide oversight and safety to make sure that this protest didn't get out of hand. We had people coming in from the community that we were concerned about. But long story short, the jury that heard the case ultimately decided, because this was a disputed fact, that in fact the dean of students and others were actively handing out those flyers. What was the argument? That those flyers were defamatory, that they defamed Gibson's Bakery, because in fact in this incident, and they had some evidence on this, we were not racist, and we certainly, and this is the factual piece, did not have a history of engaging in racial profiling, and therefore you have defamed us. And the hook to bring in the university was this. You were, in doing that, dean of students, acting within the course and scope of your employment, because you were directed by the university to attend this protest. You were passing out the flyers in your role as dean of students, and therefore you're acting in the course and scope of your employment, and therefore those acts are attributable to the university itself, all right? That's what's going on in the Oberlin case. There's another little fact that is worth just mentioning, which was around the same time, student government passed a Senate resolution, which again, you see this quote in the first bullet point. Gibson's has a history of racial profiling and discriminatory treatment of students and residents alike. That turned out to be a false statement. It was not factually supportable and arguably was defamatory. What was the hook that the plaintiff's attorneys used to basically attribute that statement to the university? That it was printed and put together with university resources, with printers, et cetera, all that sort of stuff, all right? So that's the other basis for liability here. And so let me, a few lessons about the Oberlin case. And again, it's a pretty ambitious agenda today. First off, I would make have a word of caution, which is this is a district court jury trial. Oberlin has decided that they are going to prepare an aggressive appeal of the jury's decision. If you were to ask me to guess, I think for a variety of reasons, at least the size of the verdict, that there is a very, very good chance that it's going to be significantly reduced. So number one is, this requires some context. This is a district court opinion that is also subject to appeal. If you were trying to discern lessons from this case, it is, I think, point 2, which is what you say in the course and scope of your employment can ultimately be attributed to the university, all right? And so that's exactly what the argument was here. Did the dean of students pass out these flyers in the course and scope of her employment? Because the flyers are defamatory. And to the extent the answer to that question or those questions was yes, and that's what the jury came back and said, then her defamatory statements are attributable to the university, all right? That's number 2. Number 3, when it comes to these sorts of cases, I think there is a threshold question that universities need to ask, which is, do we have a role? Should we be sending our employees into the fray here? And here, I think Oberlin probably made the decision that 99 out of 100 schools would have made, that because of the unique set of circumstances, we wanted some oversight from our vice president of student affairs and our student affairs team. They didn't have to do that, by the way, but it's probably the thing that a number of schools would do. Before we put our employees into these sorts of situations, I think there needs to be a question. Why are we doing this? And oh, by the way, are we doing this in their role as employees, as leaders of our institution, or are they doing this on their own? And just to be clear, In my opinion, had the dean of students not been doing this pursuant to her responsibilities and was just passing out flyers, she might have been sued for defamation, but there would be no way, I think, to connect that to Oberlin unless Oberlin decided to indemnify her. If we decide to send people, our staff, into these sorts of protests, there needs to be absolute clarity on what their role is in these protests. If they're doing it within the course and scope of their employment, they cannot actively participate as protesters. They have to do their job. And if they're engaging in actual protest activities as opposed to providing oversight, I think one of the lessons potentially from this case is that they would have to be disciplined. And now to kind of come full circle, I think in that sort of case, especially if they were working at a public institution, yes, there would be some First Amendment dimensions to that, but either pursuant to the Connick Pickering test, maybe they're talking about a matter of public concerns, but here the balancing interests, I think, favor the university. And number two, the Garcetti case, if they're acting within the course and scope of their employment, they're not protected by the First Amendment. I see a question. I'm right at the time. I'm going to answer questions and stay. That was an ambitious agenda. And I was making that hand gesture the entire time. Could an institution restrict what their students, staff members can say to the student newspaper or other media outlets? What an interesting question. So what I will do is unpack that question from the perspective of, in that capacity, they are employees. All right, so that would be number one. I don't think in that capacity our restriction is connected to their student status. They are acting as employees. And so then what you would get into is that full analysis that we talked about. So let's say, despite having the restriction, one of our students goes to the student newspaper or other media outlet and makes a complaint or an unflattering comment. Well, whether they've engaged in protected speech is going to depend on what they said. Was it a matter of public concern? How they said it, so that we can balance those factors we talked about. And when they said it, was it done while they were in the midst of engaging in their official duties? So that's going to be the way to analyze the individual case. I think a ban, and I'm doing this on the fly, and I could come to regret this, and I'm happy to revisit it, Michael, if you'd like. I think an outright ban that wasn't context specific, I think there would be an argument that that was an overly broad prohibition on employees' speech, which chilled First Amendment protected speech, and therefore arguably violated the First Amendment. So in application, I think we could do something along those lines. A broad policy that didn't allow for that sort of context and was just a blanket prohibition, I think would be suspect under the First Amendment. I went over by 3 minutes. I'm horribly disappointed, but that was a lot of material to cover.
You did. And Scott, there's one more question.
Yep.
I don't know if you're able to see it. There's the questions are categories open and answered. And someone just spit another question as well.
Yeah, so can the obscenity category include things like writing on whiteboards with penises, making racist comments? I'm going to say no, that in both of those cases, long story short, I don't think either one, drawing a penis or making a racist comment, there's ever been a case that would come back, at least in the last 30 years, and say that that's obscenity. I think there would be arguments, and again, I don't know full context, is it a student, is it an employee, about whether or not have they engaged in a matter of public concern, all right? So my guess is drawing a penis on a whiteboard is probably not going to cut it. Maybe there's a class where it would. So for that reason, it would be you would be okay to discipline. And then the other issue would be, and this is more along the lines of the racist comment, depending on context, depending on how it's said, the connection to pedagogy, all those sorts of things, the disruption, is it nevertheless, is it the sort of thing that we can come back and say, we're going to sanction you for it? But that's the analysis we'd have to go through. I wouldn't feel comfortable saying, no, this is obscene, or this is threatening, or this is fighting words. Those exceptions are way too narrow. Hi, Scott. A consistent challenge are items hung in windows of residence hall rooms. And this is by students, right? Yes. A default argument is time, place, manner for staff in confronting items. Others have fire safety on areas of egress. Thoughts on this? All right. So in this case, form matters. Form, F-O-R-U-M. All right. The where. We can have reasonable time, place, manner restrictions. I think, and I'm comfortable saying, in windows of residence hall rooms. And that would be permissible under the First Amendment, so long as we enforce that in a content and viewpoint neutral way. All right. So in other words, the easy hypothetical is, yeah, if you have Trump up there, we make you take it down. But if you have Hillary Clinton is awesome, we don't give you a hard time. Totally problematic, all right? It would be a real problem. But if we enforce this rule consistently, they have SpongeBob in the window, and we say you got to take it down for safety reasons. I think you're fine here. I think that's the sort of reasonable time, place, manner restrictions where the speech is had, where you would have some degree of latitude to say no. This isn't acceptable. And again, so long as you enforce it in a consistent, non-viewpoint based way, I think you'd be fine. And hi, Chris. Good to hear from you.
Okay, Scott, I got one more question. I'm going to check your chat.
Let's see if I can do that. This is a challenge. Do you want to read it to me?
Yeah, sure. Does the Oberlin case have any unique implications for small versus large schools?
So I think the answer is yes, in this sense. What I think was unique about Oberlin was because it was a college campus in a small town, that the university felt compelled to exercise some degree of oversight over what was going on, all right? So that's number one. So when I asked that threshold question, should we be involved to begin with, I'm based in Austin right now. God bless, we have protests all the time about everything. Always around 5 o'clock, always make my commute even more difficult. Do I think UT Austin, to the extent their students were involved in the protests, would feel a compulsion to provide oversight in this sort of setting? And the answer is no. So I think setting of the case in that sense, and when I think of large, small, that's what I'm thinking about, not size of school, but where is it set? I think makes a difference. It's a practical matter. Other than that, no, I don't think it makes much of a difference. I think the same sort of rules apply, which is if we ask you to cover something like this as an employee, know that what you say is potent. First of all, be very clear about what the expectations are as a supervisor. That's number one. And number two, know as an employee that what you say and how you act can be, at least under Ohio law, can arguably be attributed to us as an institution. And so, oh, by the way, if you do something outrageous in this environment, we're going to discipline you. And I think from a First Amendment standpoint, an institution in that sort of position would be on fairly solid ground.
All right, Scott, I think we have time for one more question, then we'll go ahead and wrap it up. Is that okay?
Yeah, sure.
All right.
Happy to do it.
Yep, I'll go ahead and read it out. As you observe the higher education space and work with institutions, what worries you most when it comes to how we deal with speech issues? What do we generally do right? What are our most significant gaps?
Um, yeah, so what a hard question to answer. I generally feel like colleges and universities do a fantastic job of navigating incredibly complicated speech issues. And we didn't even really get to touch on, the Richard Spencer type issues where people are coming to campus, although you get a flavor for what the principles would be in assessing that sort of stuff. So I think we do a remarkable job. There are two areas I think schools need to think about a little more. And if I see sloppiness, it's around these sorts of issues. The first one is with respect to sort of not First Amendment constitutional issues, but sort of the glib things we put in student and faculty and staff handbooks about respecting academic freedom and all that sort of stuff, which is fine. If we want to be the champions of free speech and academic freedom, look, I am a zealot when it comes to the First Amendment. I think that's awesome. It's great. But if you're a private institution and even a public institution, I think recognizing that you may be agreeing to something contractually that far exceeds anything you're obligated to under the First Amendment. So I'm always very leery about universities that use exceedingly flowery language around these issues, and I test them. How far are you willing to go with this? The second issue is, and again, I feel like you can't talk about any higher education issue without at least touching on Title IX. But I think that one of my concerns here is that our policies, especially for public institutions, are drafted so inartfully that they're capturing potentially a lot of speech that may be offensive, but also is protected by the First Amendment. And so I do think there needs to be, and there was a case involving bias response teams at Michigan along these lines as well. I do think a little more in the way of precision and being intentional about the language we use in our policies is important. But short of those two issues, to me, despite all the media nonsense to the contrary, I think universities do a remarkable job navigating incredibly complicated issues around the First Amendment.
Great. Thank you, Scott. And as you said, we're a little bit over, so I'm going to go ahead and conclude for today. So I thank you so much, Scott, for taking the time to share your talent and expertise in this area of First Amendment and just kind of helping us sort out how we apply it to our setting and our context. So it's a complicated and interesting issue. So thank you for that.
Yeah, I totally enjoyed it. Thank you all.
And yes, and I'd also like to thank our listening audience for attending today and for hanging in there with us a little bit past our hours. So as I mentioned before, this is going to be, it's being recorded, so we'll be putting it up and sending the link out to anyone who needs to view it afterwards. And with that, I'm going to go ahead and conclude, and I hope everyone has a great day. Thank you.